I have a friend that commutes for 1 day a week from here. Works for a major corporation. She's required to go 1 day a week into the office in Midtown. So she goes in there, what she do? She gives them Zoom calls.
Yeah, because not everyone has to be there at the same day. Okay, we ready?
Yep.
Okay, so let's call March 19th, 2026 Town of Rochester Zoning Board of Appeals meeting to order and start with the pledge. Pledge allegiance to the flag of the United States of America, to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I thought that too.
You saw us stand up while we were already doing it.
Slight delay.
Stacy, would you do the roll call, please?
Yes. All right, Chair Zarowski,
Here.
Member Davis is absent. Member Stevens,
Here.
Member Russell,
Here.
and myself and Mary Lou Christiana,
Okay.
almost all.
Great. Well, so the very first thing we have to do is I have to apologize to everyone who's here from the public who wanted to participate in a public comment session on the Granite LLC Verizon wireless application. There was an error in our in the public notice that was published and posted, which we didn't catch until today. And our attorney advised us that since there was an error in the public notice, that we didn't want to open the public hearing if it was not noticed properly. So we made the decision, we're just not going to hold the verbal portion of the public comment today. We're going to reschedule that after we've discussed the application with the applicant. Written comments can still be submitted, and any written comments that were already submitted are part of the record, but we're not going to actually open the comment for anyone who wanted to comment on it verbally. But obviously it's still a public meeting. Everyone's welcome to be here. But my apologies, it was my mistake. I want to make sure we're doing it right. So we decided to just not have the public hearing. And we will be sure to notice it properly when it's re-noticed. Okay, so then we just have the application from Randall Holderman is first on our agenda. You want to come up? Sit at the table, you both can.
Excuse me?
Oh, just you can come sit at the table
Oh.
here. Okay, so you all are applying for an area variance. Joe Place in Accord.
Right.
You're in the R1 zoning district. You're looking to put build an addition onto your home. And then you went to the code enforcement office. Code enforcement said you're too close to the property line for your side setback. So kicked it over to us.
Right. Question, on the cover sheet, it says appeal.
Yeah, I think that's just a mistake. It's just a variance application.
It's not, they're not appealing that they weren't grandfathered in.
Well, I guess we can discuss all of that. Yeah, because the old house is also, I think, but though they're not appealing
There's probably only about 6 to 8 houses that fall into the
current setbacks.
current setback, yeah.
Yeah.
And there's 42 houses in there.
What were you gonna say, Ken?
No, I was just wondering whether or not that was the intent was to actually
I don't know.
appeal whether or
I don't know
not
if I
they
circled
were-
that or.
they were improperly not
Maybe we
grandfathered
can
in.
correct that on the original, just have them initial.
I just-
Yeah.
Question, that was just my question.
Okay, yeah, so we'll cross out the appeal part. It is a little bit confusing if you don't know all the lingo. So we'll just have you correct that on the original and then initial
And then you can initial.
Okay.
change, so it says
So it's just area.
area
Just
instead of
aerial.
appeal. Yeah,
And then give it to them to initial.
Okay.
Please.
okay, well, we'll wait to do this quick. And basically what that is an appeal is you're saying you think the code enforcement office did the wrong thing.
There.
And a variance is you're asking for permission to do the thing that you want, but you're not disagreeing with what the
Right,
code enforcement
right.
says. Okay, so will you just walk us through what you want to do, explain why you want to do it?
Can
Well-
I do the explaining why?
he can explain what he wants to, but the why is, you know, we bought this house 30 some years ago. We had, you know, 2 little kids. And they're grown and they have families of their own, and we now have 7 grandchildren.
Oh, my goodness.
And we don't have anywhere, thank you, but we don't have anywhere to be able to have our family over to sit at a dining room table. We literally can seat maybe 5 people total. That's 3 at our island and a little bistro table. So we wanted to make our current living room, which is small, into the dining room, and then make a large living room so that I could have family over for holidays. Right now, the only time we have them over is in the summer, when we can be outside. So
So in between the living room and the original house now, you can see there's a section there 10 feet wide. That's gonna be a little sunroom, because both my wife and I love plants. And so that'll make a nice plant area, lots of window light there. And then that's like between that and the living room. So 10 foot there, and then another 18 foot for the living room as far as width. That should leave us 11 feet to my neighbor's fence on that side. Which on the other side of my house, the house was already set to one side of the property. And I think I have 9 or 10 feet on that side.
and then with our septic system in the back, there's nowhere to
Yeah,
put it in the
yeah.
back of the house.
Yeah.
Right, okay, and do you have any more, like, how far have you gotten in the planning process? Do you have more drawings than what you submitted?
No,
Okay.
I just did the rough drawings, just get us through the steps, and then, further down the line, when it looks like it's feasible, then I'm gonna.
Okay. So for now, you don't have like renderings or any like architectural plans or anything like that, okay. Great, do you, other board members have questions?
I do, this drawing is very helpful, thank you. I couldn't have done it. There's a pavilion,
Yes,
can I ask you, is that a fixed pavilion or is it with quarters?
it does have, sonotubes that anchor it down.
Anchor, like.
But I mean, it's really a piece of machinery, we can move it wherever we want it to.
I guess the follow-up to that is, I don't know, I see the septic tank, there's gonna be a field.
Yeah,
Yeah.
Yeah, does it go straight out?
that I'm not positive of, I think it might go out and tee off, so there may be 3 or 4 legs in the backyard. But I'm not sure. I've never had it dug up.
So I'm just wondering, just had you considered possibility of moving the pavilion, figuring out where that septic field is, and going with the issue, straight.
Even if I went straight back, I think it would be awful close to the leach field back there.
It would,
Yeah.
you can also, okay.
Cause I'm probably only, from the corner of the pavilion now to the tank is maybe 12 feet.
Okay.
So I'm thinking, even if you went straight back and it splits out.
Because they open up.
Yeah.
The wide, or.
Yeah.
Okay,
And-
It would also require us to, like, we would have to completely our kitchen and redesign all that to.
Well, no, he's saying let's go straight, off the kitchen, you meant?
well, you could go, this is just putting ideas out
Yeah.
for discussions.
Yeah.
Just so we're clear on that. You have a 10-foot, the sunroom you described.
Right.
You could go out from there to the backyard, what's now where the pavilion is.
Instead of
Potential.
that, yeah.
But that you think would interfere with the septic field.
I think it would be awful close if we had to move the pavilion. That is kind of why we put the pavilion there, because I didn't want to take a chance on digging a hole and hitting the leach lines,
That's a problem.
Yeah.
Yeah, for sure. Thank you.
Ken, did you have any questions?
No. Thank you for the drawing.
Mhm.
Yeah.
Okay, so, and is there any more information that either of you want from this applicant before we, because I feel pretty comfortable moving this forward and setting it for a public hearing. I mean, some other important facts about this property, it's a non-conforming lot, so it's a pre-existing lot. It exists, the house was built before the zoning code. So like the other side of the house also violates the setback
Yeah.
requirements, which feels important to me to just note in this initial conversation. But unless either of you have any other information requests, I would move that we schedule this. for-
Can I just?
Oh,
make
yeah,
one
go ahead.
comment? One of the things they have to look at is the community character. Will this be different than the rest of your community? And I know that you'd already mentioned that almost all of the houses violate the setbacks as they exist today. Maybe if you could bring in some kind of evidence of that other than a statement, go and look and,
Well, you can tell by the size of the lots and where the house is.
right, but we don't see them.
Right.
We don't see them. So if you could say,
Alright.
count
Some
them, or take some,
pictures,
yes, take some
yeah.
pictures or something.
As far as the look of it, I mean, it's a residential, we're all,
And our house is a cape.
a cape. Just putting the,
Mhm.
going a different way, we have a plan for it, but I mean, and I think it look nice, we have a newer house across the street from us, I mean, we maintain our property very well.
You plan on continuing in the style of your existing home?
Yes.
The Cape style?
Yeah.
Well, no, it's not gonna be a cave.
Yeah, it is.
They don't have those architectural renderings yet.
It's good. Yeah, well, it is, the roof line on the sunroom shoots the same way as the house.
And then you'll go the other.
The other
direction.
shoots back the other.
I think
That's the
what-
only difference, but I plan on having at least a 9/12 pitch, but I'd like to go with a 12. Our house has 12/12.
I think what Mary Lou is suggesting is just if there's some other houses in the immediate neighborhood that also are showing, that it's on both sides of the property, that it's close to the property line.
Right.
That's just helpful for us to answer the question about is it in keeping like. I can see a bit from the aerial view on Google Maps.
Yeah,
Yeah, and the street view on Google Maps too, but if you even just took a few pictures and
Okay.
sent them to us.
Right, yeah, you guys have to provide the evidence.
Yeah.
Maybe it's pictures from Google Maps.
Exactly. Okay,
And one other point, Celie, I don't know, any neighbors who would be like welcoming
Well,
or don't care?
We're really good friends with our neighbor who we would be going towards her house. She is, in full support of us.
So
So
submitting a statement from her for the
Okay.
record would
that's
be
great.
in your favor.
okay.
yeah, and they'll get a notice in the mail too when we.
Yeah.
Okay. So I'm gonna make a motion that we schedule this for public hearing at our April meeting, which is on
16.
the 16th. Thank you. Do I have a second for that motion?
I'll second.
Okay, any discussion?
Could I just ask what that means?
Oh, so the process is, you guys come, you talk to us, this is like your preliminary meeting. The next step is if we feel that we have all the information we need, we can schedule a public hearing. Which means that a letter will go out to all your neighbors within 500 feet. Just saying that you all are asking for a variance to do what you just described. There'll also be a notice published in the newspaper and on the town website. There's a small fee for doing the publication of that's on top of the application fee for here. And then at our next meeting, anyone who wanted to speak either in favor or against, in terms of why we should or shouldn't grant the variance, they could do that. Then once we felt like we'd heard from everyone in the public and had all the information we needed to make a decision, we can close that public hearing. And then we can make a decision on whether to grant, deny, or modify your request.
Okay.
Yeah. That answered that question for you? Great. Okay, so all in favor of scheduling that public hearing? Aye. Anyone opposed? Anyone abstaining? Okay, That motion carries, so we'll schedule that for the 16th. And we'll put the notice out.
Yeah.
And if you have anything else you want to send to us in the meantime, just go ahead and submit it to Cindy.
So take those pictures and submit it before then.
Yes.
Or anything else you think of, but I think we have what we need.
Okay.
Great, thank you guys so much.
Thank you.
Okay. Thank you guys. Okay, so the next application on our agenda is, what is it? Granite LLC and Verizon Wireless. For those of you who weren't here at the very beginning of the meeting that are from the public, we had a clerical error that is my fault in how we published the notice for the public hearing that was scheduled for tonight. And our attorney caught it and advised that because we had not properly noticed the public hearing in the paper and on the website and everywhere that it was posted, that we should actually not open the public hearing tonight. So we're not gonna open that up. Written comments and any comments that were already submitted are part of the record. We just don't want to have a situation where people are commenting and there could be a question about whether those comments were part of the official record for our process. So that's why we're not doing that. We will, we intend to schedule that and renotice it properly so that you all will know, but you're welcome to be here, but we're not going to have a public comment portion. Okay. So welcome, Mr. Olson, right?
Correct.
Okay, well, I know you've been in this room many times, but not in front of this board.
A few.
If you could just introduce yourself to this board, and we all got your letter.
Okay.
But if you could just give us a quick
Sure.
explanation about what you want to do and where you're
Absolutely.
at.
So my name is Scott Olson. I'm an attorney with Young Summer out of Troy, New York, and I represent Verizon Wireless. So back in November of 2024, we submitted a combined application. It was a variance application to this board and special use permit / site plan to the planning board. Long story short, as you know, the planning board is basically the lead agency for seeker purposes. You're doing a coordinated review. So you can't make a decision until the planning board completes seeker. So that's why this is the first time you're seeing me. I didn't want to rush here, like in February of last year, because we were, well, over a year away from that, and then you would have forgotten me. So what we're looking to do though is, we're looking to put up a 145-foot cell tower. It'll be within a 50-foot by 50-foot secure compound off of Granite Road. It's the apartment complex. I think you have all the site plans. The planning board when I met on the 9th of this month, they were supposed to have issued their determination of significance under seeker. But they didn't, they decided they needed some more time. So they're gonna meet the 30th of this month. Their determination, they've completed their part 2 of the environmental assessment form. They completed the draft part 3 of the environmental assessment form. They completed their draft declaration of significance. So while they have not approved it, they can decide anything, but the way things are going, if it stays the course, it looks as if they will issue a negative or conditional negative declaration. Again, they can change their mind. It doesn't have to happen. But I think it's important for the context here, because if they do issue a conditional negative declaration, one of the conditions will be that the tower height get lowered. They want to lower it from 145 to 125. While we don't necessarily agree with that, if that's what they're going to do, we will live with it. That's significant for really 2 purposes. One, you can't act until they do a determination of significance. And 2, if they lower the tower height, that affects the variance application. In fact, as I set forth in, maybe it was an email to Mary Lou.
Yeah.
It might have been in one of my letters, but if the tower height comes down to 125 feet, I don't think we need a height variance. And we provided some documentation to demonstrate that, because your code has a maximum tower height limit, which is equal to the nearest height of the tree line plus 50 feet. In the initial application, our engineer made a mistake. He thought the nearest tree line was about 40 feet, 45 feet high.
after the pretty extensive visual analyses that we did, including drone flies, they determined that actually the closest tree line is to the south of the compound, and those trees are about 80 feet tall. So if you take that 80 feet and then you add 50 feet, we're at 130 feet that we think we can legally, without a variance, build. Obviously, this board would have to look at that information. It's documented. We gave the same information to the planning board. But we have a tree height map in there. We have distances. We have pictures of the drones that show you what the height is. You can see the elevation. Obviously, that's for this board. Well, my argument is if on the 30th, the planning board says, we're gonna do a conditional neg deck, drop it down to 125. I don't think we need a height variance. But again, we don't know if they're gonna do that. Our application is for 145 feet, so that's why it's, I think, should probably be noticed for that also, but it could change. So I just wanted to let the board know about that.
So Scott, if the planning board conditions the negative determination on the reduction of the tower height from 145 to 125,
Yes.
do I understand you as saying it's your position that you do not need a variance?
That is my position based upon the tree height data that we have provided, yes.
And in that case, are you gonna be withdrawing your application to this board for a variance?
I think that's a great question. I think it could, we could withdraw it. I haven't decided, I haven't figured that out. Or this board could look at this and say, you don't need the variance. I don't know what.
Or maybe, I would think, if they do that, you might want to go to the building department to see if you still need a variance. Because that initial decision, I think, should be theirs.
Yeah, they made the initial decision before.
Right, but it was based on a lower,
It was not, unfortunately, the prior building inspector didn't seem to understand that provision because he just said, hey, you're above 35 feet, you need a
Ah,
variance. So
okay.
he just looked at the district stuff.
And one other thing, given the planning board's role to date, do you expect that they are gonna make a finding of fact as to the tree line height? And if so, will we be
No.
bound by that determination?
They will not make that. In fact, I initially, because the code allows for them to grant a waiver, we asked for a waiver from them on this issue. It got super complicated. At one point, their planning board attorney came up with this 9-part test of what they should consider for the waiver. And they said, well, you need to go to the CEO for this. And I said, wait a minute. The variance standard is a simple 3-part test, because I'm not sure if you're aware of what this test for public utilities. Let's just be blunt, is pretty easy compared to your traditional variance standard. It's intended that way. The courts want them to be granted generally. So I basically withdrew my waiver request from the planning board because it was going to go to the CEO. There was going to be litigation. We have the shot clock in play. I know all this is firsthand knowledge to you. But I thought, let's just get to the ZBA, let them make a decision. But we'll see. I don't think they're going to make a decision on that, on the tree height, because I think they're leaving that to this board.
But how could they make a determination on environmental impact if the tree height is critical to determining that very factor of the difference between the antenna top and the neighboring trees? It seems to me that's a critical decision that they have to make, without which they can't go forward.
So again, another good question, but they can look at the photo simulations, which we've given you copies of. So whether they say the tree height, the fact is there are trees in that area that are 40 feet in some locations, that are 80 feet, that are 100 feet. And that's just a fact. And we have pretty extensive photo simulations that we've given to this board. So they can just look at the photo simulations and say, well, I would encourage you to look at them, because when at the planning board, I gave a presentation on the screen, and I said, okay, here's a simulation of the tower, and people were complaining, I don't see the tower. You really can't see the tower from most locations. It's because it's in a valley. It's very difficult to see.
I'm sorry, I don't mean to hammer this point, but
Go ahead.
it seems important to me. If if you're saying that they are the lead agency, in my perhaps limited understanding of what that would entail, they are pouring resources into eyeballing this from top to bottom. And they have the ability to hire engineers independently, and it seems like a critical fact, and I don't understand why that would come to us without having been determined. Otherwise, it would be incumbent upon us to make a separate determination as to the tree line, and that would then feed back into their determinations on the environmental impact, I would have to think.
I don't think so, and here's why, because again, I think if they don't have to say what tree is this tall or that tall, they just have to look at the evidence, the photos, the balloon test that we did. And say, what do we see and what do we not see? But you're the board that's actually charged with the variance requirement. So if I'm asking for a variance, if we need one.
Well, that's, I mean, I guess maybe that's partly what you're getting at. But it's a thread that I wanted to pull out a little bit. Like,
Sure.
it sounds like you don't, right now, it's not your intention to withdraw,
No, it's not.
but it sounds like it would be your intention to comply with the conditions of that hypothetical conditional.
Yes,
Okay.
we will.
So even if you agree to reduce to 125 as of now, it's your position that you're gonna move forward with the variance application, but you would modify it for the height of one, right? Because it becomes absurd, right? If you're, which is part of where I thought it was intersecting with what you were saying, is if the planning board doesn't issue a finding that the relevant tree height is 80 feet, right? Then I guess right, like if that's contested, then you might still need a variance until we determine what the tree height is.
Well, that's why I'm coming to you, but
Yeah.
I guess there's, like I said, maybe the way it gets handled is if the planning board requires a reduction in tower height. Maybe we consider withdrawing the variance application. Because I'm confident that we provided information that demonstrates that we wouldn't need it in that situation. But I can't just withdraw it now because
Right, because you're not there.
I don't know what the planning board's gonna do. They could change their mind. I don't think they will.
I think we have to wait and see.
Yeah.
What the
Yes.
planning board does
Mhm.
and how they do. Phrase their.
Right.
Their secret determination.
Right.
Okay, so for right now, then, for this board, with the current application that's in front of us, it's for the 145 feet plus the 4-foot lightning rod.
Correct.
And
Oh.
the setback.
And the setback variation, which would still be in play.
Yeah.
Separate from the seeker.
Yes, and on that issue, if you don't mind, the tower height reduction, should it occur, changes the setbacks, because the
Right.
setback requirement is 100%, 110% of the tower height. So before it was 145, it was 162-ish or something in that
Right.
ballpark. If the tower height now comes down to 125, I think we need 137. So we have 150 foot, and the weird thing is, this is the only law I've seen it in 30 years. You measure the tower height setback, not from the tower, but from the compound fence. Be that as it may, that's your law. Yes, usually you measure from the tower height. Having said that, we are going to have a plan adjusted for the planning board that shows since we have a 155-foot setback on the south side, we're gonna shift that back 13 feet-ish or so, give or take. So we'll have the 137 we need. That will give us, we have 124 in the front. That will give us 137.
Oh, I see.
So we're gonna show a plan that complies. Having said that, the code also does provide for the planning board to consider the fact that we have a breakpoint technology in the tower, and your code actually defines breakpoint, and we have it. So the fall zone, it gets effectively reduced, and at a 125-foot tower, the breakpoint's like 62 feet or so. The planning board has indicated that they will likely take that into consideration if we can't meet the setbacks. Having said that, I don't know what they're gonna do, final decision, so I wanted to make sure that was included in this variance.
Okay.
It's
No,
complicated.
that'll make sense. So, right, so the setback, the setback variance might also be obviated if you change the height
That's correct.
based on the seat, there's conditional stuff stacking, okay.
Yes.
But with the current situation, yes, there's a few questions that this board has to think about. One is just, I spoke with our attorney, Mary Lou, and she agrees with Mr. Olson's analysis that the public utility standard does apply in this situation. So I just wanted to make sure everyone on the board had an opportunity to ask questions to Mary Lou or to me or to Mr. Olson about that.
Sam, maybe you could just describe what that means.
Yeah, so the public utility standard, and there's enough, there's a majority of lawyers at this table, so here I am, not a lawyer trying to explain it. The public utility standard is basically, it's a state courts have ruled that when something that is a public utility requires a variance, that there's a different standard applied. And the reason is that public utilities have a requirement to provide services, and you don't want municipalities or other local government entities to get in the way of the public utilities having the ability to provide the service that they're required by law to provide. So there's a separate variance test than the normal test that we apply. The test for public utilities is 3 parts. The first part is do the current conditions have a gap of service that the utility is required by law to work to correct? So that's the first test. Is there a problem that they're actually trying to solve? The second test is, does the proposed project actually remedy that problem? It doesn't have to remedy it completely, but it has to make a significant, it has to actually speak to the problem that exists. And then the third test is, are you remedying that problem using the least, or, with minimal impact to the community in order to remedy the problem? Did I do okay?
Spot on.
So that's the standard, and there's stuff in the record. I mean, we have to review all of this according to that test, but there's a lot of evidence in the record, especially considering all the work that's happened on the planning board side, that speaks to certainly the first 2 of those questions, and I think also to the third. So the first 2, there's a lot of engineering data that's been submitted by Verizon, but that has also been reviewed by engineers retained by the planning board. So there's engineering analysis both from Verizon and then also from the town's retained engineers that speaks to both the need and also to whether the project addresses the need. And then the third question, is it done minimally? There's some questions, I guess, about, are there other locations? Is the height that's proposed actually needed to remedy? So we also have stuff quite a bit in the record that speaks to that question.
And of course, we'll be listening to the public.
And of course, we'll be
We may
listening.
get a whole
There's also a lot of
more
comments.
information, yeah.
There's also a lot of comments in the planning board record that speak to all 3 of those questions as well.
And they'll speak to us.
And they'll also speak to us, yes.
And forgive me, but are those the first 2 factors, are those determinations that the planning board has to make as
No.
part of
No,
the
they're our
secret? That's what's
determinations.
distinct.
That,
From the
those
planning board
3
process.
things, right, they have a different standard of review. The zoning board standard under public utility is much easier than to get a waiver. To get a variance is much easier than to get the waiver, I would think.
Having said that, I think the code does require the planning board to make a bunch of findings, including, is there a need for it?
Well, that's what I'm trying to get at, because in my experience, ordinarily, there's a principle in the law that if a determination on a matter of fact is made before a body, it doesn't generally get relitigated in front of a subsequent body. So I'm trying to understand, coming into this, where we have independent room and where we might be bound by what's determined at the planning board stage.
Right, no, that's a very good point. I think it's kind of dual jurisdiction here because of the nature of the variance standard. That is the standard that you have to apply, should we need a variance. On the other hand, there's a very specific code requirement that says, one of the factors that has to be determined by the planning board is, do you need the site? That's under the special use
And
permit.
that's to grant a waiver. They may say,
Yeah.
we're not granting a waiver. And then they could come to us under our standard. They may not grant a waiver under their standard. And we may not either, but we have to look at that.
I guess, Mary, thank you, but I guess what I was trying to understand was, aside from the waiver question, just in order to approve the site plan with the conditional negative declaration, do they have to make findings of fact?
Yes, they do. And I don't believe they've made any findings of fact. I don't think they've drafted a draft decision yet. But they have drafted the seeker draft.
Which they have to
And
do
I
before they-
don't know if they've put need in there or not. I mean, it really is more for their site plan approval application, which, assuming they get to that point, will come after the seeker is done.
Is that public hearing still open, Mr. Rose?
No, I think so.
I think so, right?
I think so.
I see a lot of people nodding.
7, 8 meetings at least. or
Right,
something like
okay.
that.
Okay. Did you have any more questions on that, Ken?
No, thanks.
How about you, Michael?
Also, for us, we'll have to see what the final determination is from the planning board. and see-
For seeker.
Yeah, to seeker and to see to what extent they've addressed the remedy question and the gap question.
Yeah, and we have to
Yeah.
look at what's in front of us for that.
Right,
Yeah.
right, separate from whatever the planning board
Yeah.
does.
And that information's in there. We gave you the engineering analysis and the, the town's RF consultants review, a couple of letters. And both of them confirmed that there is a need for it. It's a need for both, so there are two purposes. One is basically coverage and capacity. We've demonstrated there's a coverage need. There just isn't signal from Verizon in this area. There may be signal from other carriers, but that doesn't preclude us from making an application. Now, I know some of the neighbors have said that's the case, but they're just not applying the laws that currently exist. The FCC has stated clearly, each carrier has a right to provide their own service in an area, even if service is provided by another carrier.
Now, with that, sorry to interrupt.
No, please.
If that monopole comes down from 145 to 125.
Yes.
Those other third party, I think there are 3, right? The
Yes.
Others that would be
Yeah, three.
situated on them vertically, right below the Verizon antenna, correct?
Yeah, we have, no one's reached out to us, but that would be available to them
I
for
think
publication.
I think I read that materials will be underneath,
Yeah,
like
Yeah.
one under the.
unless, go ahead.
So I guess my question there is, do those, since they're gonna be below that 125, Verizon will have better coverage, right? They'll have.
We'll
best
be
coverage
we'll be
because
10 feet higher.
They'll be higher,
Yeah,
right?
right.
But I mean, it stands to reason that if you're 10, 20, maybe more feet below that, your coverage is gonna be far less. I don't know if it'll be effective coverage.
No, that's a great point, and it's a point that I made to the planning board to say. Your law requires co-location. If you lower the tower, you may be effectively limiting people to co-locate because the company could look at that and say, we don't want to go there, it's not worth our time. Because Verizon, even at the 125-foot level, is saying, this is marginal for us, and
But
we're not
that's-
happy with it, but we get it.
Does that not strike you as a potential catch-22 where if you go too small, you can't provide the service, the other vendors can't provide the service, you go too high, you're violating the variance.
Well, that's correct, and that's why we were pushing for the 145. We were saying, number one, we need it. And we thought we demonstrated we needed it, but I also argued. The lower you go, you may be precluding other carriers, and the planning board said that's our decision to make if we decide to do that. We might be willing to do that. So,
But at that 145, the tree height really becomes an issue. I mean, in my own personal, I don't know that you have that there.
what's
You're
that?
saying you have to the south, the tree line at 80 feet.
That's the nearest tree line, and behind that,
That's
they
the-
go to 100 and a little taller.
So just help me out, what's south? What are the?
Okay, so south would be just 180 degrees from Granite Road. Okay, so if you're looking into the property from Granite Road, you're looking south. If I remember correctly with my plans.
Talk about the
So
White Pines.
Yes.
Yeah, the White Pines and looking
White
towards
Pines.
Minnewaca.
And you're saying that that's the nearest
That is the, yes,
tree line?
yeah.
Really? How
It
did,
is.
may I ask, and maybe I'm jumping ahead too far, really?
Well, I was
far?
gonna say, like, the first thing that I think we need to, we've agreed on the public utility standard. And then I think the second question is, what's the tree lines?
Yeah.
Which is now what you're getting into.
That is.
Because I think from the record that was submitted, we have a lot of tree heights, we have a 360-degree. And it's a question to answer. Like, and we would have to do it as a finding of fact, is like, what is the nearest tree line and what is the height of that tree?
I
line?
would like to know the perspective.
Yeah.
Right,
Yeah,
like,
great.
what is, how do you define tree line in words?
Well, we did provide it in, Tectonic provided it in a letter.
Because to me, it's a line of trees.
Correct. That's absolutely correct. And that's what they did. They provided a map of their findings, and you obviously can't see the details of it.
Yeah.
But the tower is right there. This is the closest tree line that the beginning parts of them are 80 feet. Back here, they get to be 100 feet or so. Up here, it's more scrub, 40 foot or so, but it's the nearest tree line to the tower. The tower, they have the distances listed, that the 80 feet is the closest.
So let's just assume that I was there yesterday and there is potentially, I don't know, this is for discussion, but. The apartment complex,
Yes.
is there a tree line between the proposed site and the apartment complex? Because to my memory, there
Yes.
is.
There is. In fact, this, I think, helps us in the sense that, and again, you can't see it, but there's all this cross hatching.
Yeah.
And the site's kind of in the middle, but there are just tree lines around the entire, it's 360 degrees, more or less around.
Going along sort of like, I don't know if it's a stone wall, but that's kind of separating. Where the apartment complex
Yeah.
is and where this.
Yeah, but there are trees in that area. It's,
Because those aren't white pines and they're
No.
not,
no, but they're further away from, again, it's the closest tree line. That's what
Yeah,
the
I
code
know.
says, yeah.
they seem the nearest, but I could. be wrong.
But maybe you didn't know exactly. I don't know if the site was staked or not, probably not.
I didn't see things.
So you, and then they have it exactly on the plans are engineered and they measured it. So in fact,
Yeah, it wasn't staked,
yeah,
we could tell approximately. But not,
Would it be possible to
Precisely.
have it staked, but. I don't know.
I don't see why not.
I mean, we've doing a site visit, I don't know how useful it is, if we don't know. Where they are, that is.
so what you're saying, like, just looking at the tree height map that you were looking at. What you're saying is that in the crosshatch where it's, I guess, like the pink color. And also overlaid on the green crosshatching, that's a mixture of trees that are between 40 and 50 height and 70 and 80 foot height. You're saying there's two different heights. In there, and you're saying the closest one is the one to the south. Which is a mixture of tree heights, and then if we were to go further south, that's where you're finding the 80+ foot. trees.
Yes,
Just I'm reading that correct?
yes. Yeah. Yeah, and I think the whole point of that provision and the tree line is just. It provides screening, so that's why if you have more screening. You can go higher, basically. I think that was the intention of that provision. Again, but I didn't write it, so I can't guarantee it, but
Mhm.
yeah.
Mhm. So it sounds like one thing we'd want to see is the actual tower location staked out. I guess, because yeah, we didn't go when there was the balloon test because we weren't looking at this yet.
Right.
Just to help, I mean, because we have the submission, showing y'all's tree height analysis. I don't think that that's something that the planning board has had any engineers review. So that
Yeah.
would be something that I'd expect that we would want to have our own people look at.
Sure.
Just to, make sure that everyone reaches the same conclusions. So any other?
Understood.
questions that you all had about the tree height.
There's a wetland in between, right?
There are a few wetlands and there's culverts, but yeah, most of the wetlands are kind of to the west of the site. And so even though you have more width of the property to the west, to get through there, you're gonna have to interfere with some wetlands. That's why it kept us to where we are. Yeah.
And I guess then the third question that I wanted to talk about tonight, so the first was the public utility test, the second was the tree height. The third is that third prong, right? Like why 145? And one thing I'm hearing just straightforwardly from you is that you're okay with 125. Which
Well,
seems to me.
we'll
are
live with, well,
straightforwardly
no,
against-
no, my RF engineer doesn't want 125. But when I talked to him, I said, well, you have two choices. 125, if that's the decision, you sue the planning board and see what happens. Or can you live with it? And it's a compromise. That's what it is. But he has the analysis in there that shows that at 125, yes, we're gonna lose coverage in certain areas that are important. You know, it's not gonna be massive blocks of areas, but so the bottom line is, he said he can live with it. And you can, you know,
Right. I mean, I guess
That kind of
that
says
speaks
that you only
directly
need
to
125.
necessity, right?
well,
I mean, I guess. my-
no, it's a risk analysis. We've spent so much money on this site already. The amount of escrow that's been submitted, at some point Verizon looks at this and says, do we want to spend another, you know, whatever, $50,000 doing, you know, fighting this or not? It's a compromise. But
Just a follow question on the, so there would be some spotting, I guess, there would be good coverage. And that's from the Verizon's location on that monopole.
correct.
But again, going back to down that pole to the other vendors that have the right to be on that pole. What's the answer, what's the analysis from your engineer about what coverage they're going to be able to provide?
There is none. We don't know. We can't provide an analysis on collocators. We don't know their network. Every network is different. Our networks are not identical. And I know that sounds funny because they're all cell companies, but you know, they've been developed independent of one another. So you could have, and so like, there are 3 existing cell towers in your town right now.
Mhm.
We are on 2 of them. The closest cell towers we call Kerhonkson and the other one we call Accord. And we're on them. I think the other carriers are on them. Having said that, just because you're on a cell tower doesn't mean you're providing identical with another carrier, doesn't mean you're providing identical service. Those antennas could be at different azimuths. In other words, they're pointing different directions. They serve slightly different purposes. They're gonna provide similar, but not identical.
But if they were lower down a pole,
If you go lower, listen,
objectively, I mean,
height,
be less coverage.
height is king in this. So we don't know what the other carriers' needs are. But if they have a need for this location, if they go lower, especially a carrier that has to go 20 feet lower, 20 feet's a big deal.
I don't know the answer to this question, so I'm asking it.
Yeah.
Is there an obligation on the part of Verizon to determine what the coverage area is for those other?
Not at all. No, we can't. It's actually, it's impossible to figure out.
Other,
Yeah, we need to know their network, the existing sites, what antennas they're using, all the equipment, the radios, et cetera. Just can't do it.
So I guess this sort of along the similar lines, and forgive my ignorance, is there, it didn't seem to me that there's any like laws that say that you have to allow, well, you have to allow for co-location, but I read in your, sorry, let me back up. I read in your engineering necessity case
Mhm.
deck, there was an addition to it at the end. There was a response to some planning board questions.
Yes.
And one of the questions was about this third tower in town that's
Yes.
Verizon doesn't have service on, and you made the argument that that's a separate question because it wouldn't address the same coverage gap. But one of the things it also said is you intended to propose a 15-foot tower extension to that city hall
Yes.
tower. And that just, I mean, I know this isn't before us right now, so if you don't want to comment on it, I understand. But
Right.
one thing that occurs to me, if we end up with a 125-foot tower, is that a year from now, T-Mobile comes in and they say, hey, we want this to, co-locate on this tower. I don't think anyone wants there to be more cell towers, but they say, we need to put another 20 feet on this tower because if we go below the 125, we don't have coverage. And your code requires us to seek co-location rather than try to build a different tower. Like, just, do you have any thoughts on that hypothetical?
I do, and that's very astute. And yes, we are planning and we put it in the document, so it's out there. I don't think people are focused on it, but we are going to go on the City Hall Road Tower. That tower is about 4 miles away from the area that we're serving.
Mhm.
Our Kerhonkson site is 2 miles away, but in the same direction as that city. So the point being, the tower 4 miles away cannot provide service to the area that we're talking about. If you have a tower that's even closer. Having said that, co-location, yes, another carrier could come in and say, they'd have to come to the town
Mhm.
and say, we can't go under 125, we need to go higher. And they can actually make an application, and they could probably make it under the Spectrum Act, which allows pretty easy, well, relatively easy tower extensions in certain circumstances. In this one, I don't think it would be as easy because I think the town would argue you're kind of changing the stealth technology or the visual aspect of this, so it doesn't fall automatically under the Spectrum Act.
How much would the trees have to grow to do that? Are these mapping trees?
What?
Are they gonna? It's,
Well, again,
I don't kind of variance with that.
if it, so if it falls under the, let me answer it this way, if it falls under the Spectrum Act, towns don't have much jurisdiction, if any. In fact, on the City Hall Road Tower, we're proposing an extension that, while we might have to make application to the town, under the federal law, it can't be denied. So, there's a lot of leeway in that respect. Having said that, to address the planning board's concern, we did amend our lease agreement with the property owner. And in that real estate agreement, the tower height is limited to 145. So while it could go up to 145 under certain circumstances, because that's a real estate transaction, the federal law doesn't, wouldn't trump that.
Yes.
So that tower cannot
Property
go.
always wins.
What's that?
Because private property always wins.
Exactly. The federal law doesn't basically interfere with private transactions like that.
But would there be anything preventing you from amending that lease agreement in the future?
I'm sure there's gonna be a condition in the planning board.
Right. But then it gets a little.
Resolution,
Yeah,
you
okay.
know, but yeah.
Okay, so one of the. Well, I guess maybe another question is if with the. How to formulate this. If you choose to reduce the height of the tower as part of the conditional seeker approval, would you still be seeking a variance for 145
No.
here? You would not, so it would just be like,
No.
we want to make sure the 125 is good.
No, if that were to happen, so if on March 30th, the determination of significance comes from the planning board and they condition it on reducing the tower height to 125. We are gonna make a determination about whether we should even withdraw the application entirely from you. Because it doesn't sound like you would be willing to say, you don't need a variance. So if that's the case, we may just decide we don't need the variance, and if people want to sue on that, that's fine. We feel really comfortable defending that.
But I guess you could put it forward and then we could rule that it doesn't need a variance, but
That's,
Right, okay.
But Tim, if we didn't. But if we thought it did need a variance,
then we would have to either.
and
issue it or
we,
deny it.
and we, granted the variance.
Mhm.
Then I think the planning board would be in a situation where they made a secret determination based on the height at 125. And now we have come along and said, no, Verizon, you can go up to 145.
Oh, right, if we.
And I would
granted
seem
it
to
one-
negate
but he's saying
the
that
very
wouldn't
basis
have-
of them
Said
being
they
the
reduce
lead.
it to 120.
He said they would-
That's what's.
no, we would, so, okay. I didn't finish my thought. I guess there are two scenarios. If the planning board cuts it down to 125 on March 30th, we have to decide, do we withdraw the application entirely from this board? Or do we simply say, we would like to amend to say that, it's 125? And decide what you think we need, because again, I don't think we need the variance, but that's your jurisdiction.
Okay.
Okay.
Okay. I think for me, that addresses all the questions I have right now. And it's also all the information we have right now. I guess one question for you all is, do we want to ask tonight? Or, because can we ask for escrow too? Can we do that? Like, how does that work if we want to?
We can.
Okay, so do we want tonight to say to them, hey, we're gonna need to retain our own engineering consultant to review this tree height stuff? Or do we want to say, let's schedule the public hearing, see how that goes, see what happens with seeker in the planning board, and then at our next meeting, decide where we're gonna go? Does that make sense as two choices? Is it? Yeah. I mean, my personal, go
Yeah,
ahead.
how long has this been going on already?
Since November of 2024.
Yeah.
So
What's the urgency? Is there some urgency here? Or?
I mean, I was gonna say my inclination would be to just, since it sounds like Mr. Olson has a sense of where the wind is blowing with the planning board. And I, for the purposes of this board, if we can not have to issue any variances, that's always, I think, the best outcome. I'm not personally inclined to ask them to put up money for us to hire an engineer. If we can just wait a minute and see what happens with the planning board.
And you might want to spend some time between now and April checking with engineers to see
What that would cost.
what it would cost, rather than just.
Right, rather than just asking. So that's what I'm inclined to do, but
Is it an engineer or forester or?
that's one of the things we would have to
We would
You'll have to,
determine.
that.
you'll have to figure out what you.
Have our
really
own
need.
expert
Yeah.
look at the tree heights, yeah.
Is there a time frame within which you would, let's say, comply with the request for bonding? To have the escrow account? In other words, how long would it take to get the escrow account so that we could actually engage an
Not long.
engineer?
not long, the request comes in, we pay it, we front it for Verizon, so literally I can turn it around, I can turn it around in a day or two. It's not a long time.
Sam, are we on the clock in any way? Or is it-
No, we don't have any clock yet because we haven't closed the public hearing.
Given that, Sam, I don't see the urgency right now until, like Mary Lou suggested, we actually identify people who could provide this service.
Okay. Do you want to give us money? Or are you also okay with this?
No, listen, if you would need to retain a consultant, of course, that's something that we would pay. It sounds like you might be suggesting to not schedule the hearing again until after the planning board makes a decision, or?
No, you
Well, I
take
want to
it.
schedule the hearing.
Okay.
At the latest, it would be at our next meeting. I was actually gonna float to the board whether we should do a special meeting to have the hearing because of the mistake that happened tonight. But we haven't had that conversation yet.
Okay.
But it would be, I think either way, it would end up being after that planning board meeting, because the planning board meeting's what, on the 30th, you said?
Next
Mhm,
meeting-
yeah.
Next meeting?
And yeah,
And
so
this is
either way, it would be after that, because our
Correct.
meeting's the 16th, and if we were to schedule a meeting, it couldn't be the same day as, like, it would probably be after the planning, yeah, it would be after the planning board.
Yep.
And you're not here in the beginning of April, and we only
I
have,
was gonna say we have
we don't have a quorum,
Passover is then.
Passover, yeah, so I think it's just gonna be our April 16th.
I was gonna say, and I have
That's
meetings 2 nights.
Well, hopefully
a
the
week every-
town board appoints a new member for us.
So then we'll wait to see what happens on the 30th, if anything, with the planning board. You're not gonna have a quorum.
Well, we have a fourth member,
Okay.
who's just not here tonight. But,
Oh, okay.
yes, but we sometimes have quorum issues because we don't have a full appointed board right now.
Okay.
We need the three.
So then I guess I could plan on being here, but I can contact somebody about if there's a quorum. not head down.
We should know ahead, hopefully.
I could look, yeah.
And
Okay.
hopefully the planning board, I'm sorry, not the planning board, the town board has had some other applicants that they've interviewed. They just haven't appointed a new person. So that would also obviate the
Okay.
quorum stress.
But the 16th would be just a regular meeting, and then we can talk about what the planning board has done or not done.
Okay, so I think in terms of asks from you, we don't have any,
Okay.
except to keep us updated on any decisions that you make as a consequence of whatever the planning board does or doesn't do.
Sure.
So a request to mark out the area.
Oh, yeah, to stake, so
Can
that
we
we can
do
do
that
another site.
Between now and the next meeting?
Yeah, if you could do that, that's an ask that we have.
Got it.
And then we'll
Well,
do some outreach to figure out what kind of experts we would want to retain to look at the tree height and what kind of cost we would want to ask for in terms of escrow. Do you guys have anything else from Mr. Olson?
There's a guy on YouTube who takes a yardstick and he can tell you the height of a tree, so.
Yeah,
But
skilled
I don't think we're
triangulation.
gonna go with that.
Yeah, send him a note, you know? Okay, so I think that's it for chatting with you. What we need to do then is, we have two motions we need to make. One is, this application has to be referred to the Ulster County Planning Board, the variance application has to be referred. So I'm gonna make a motion that we refer this application to the Ulster County Planning Board. Or a second for that motion.
It's like,
All in favor? Aye. Anyone opposed? Okay, that motion carries.
And can I just comment that they probably will not look at this until their May meeting because they need everything 12 days in advance. And their April meeting is April 1st.
got it.
So,
If they already, you have to send it, of course.
Yes.
They have looked at it
right,
and they determined local determination, so
right, for the
I'm not
planning
pressed
board,
in,
but,
but I'm pretty sure you're gonna see local determination,
Yeah.
but you still have to do
but
it.
we have to
Yeah.
wait. So if you schedule the public hearing,
For
it
the
will be
16th, we'll
continued
have to keep it
anyway.
open.
Sure.
Okay, so then, based on the conversation we just had, I'm gonna move that we schedule the public hearing for our April 16th regular meeting. Do I have a second for that?
second.
Any discussion on that? I know you're away, but. Okay, so all in favor? Aye. Anyone opposed? No one's
Did
opposed.
you vote on the planning? You voted on the Ulster County.
We voted on the Ulster County Planning
Okay,
Board, right?
yeah.
Okay, so that's what we're gonna do. We're gonna renotice the public hearing. We're gonna refer to the Ulster County Planning Board. You're gonna stake the tower location.
Yep.
And then let us know so we can go look at that again and keep us up to date if anything changes based on what the planning board does.
Will do.
Okay, thank you so much.
Thank you very much.
Okay, next on our agenda, I think, is other matters. We don't have any minutes to approve. It was a very busy month for our secretary, who's doing an excellent job, so we're just gonna punt on minutes till next month. I don't have any other matters. Do any of you? Okay, well then I'll motion to adjourn our meeting at whatever time it is.
7:34.
7:34. Okay, meeting
Second?
adjourned. Yeah,
There's a second?
okay, there we go.
Now we're